allegation number 15. Mr. Speaker, we made also other general observations that we felt should not reach this House, that the MCAs should exercise their oversight role at the county level. Mr. Speaker, including this particular case where there were accusations leveled against specific counting officers, county accounting officers, that is the chief officers. Mr. Speaker, we have made an observation that MCAs should take note that it's not the constitutional mandate of this House to deal with violations of county accounting officers. And this is a matter that can be dealt with by the counties at the county level. Mr. Speaker, on issues of reshuffling of chief officers that featured, again, the committee made an observation that these are matters that should really not find their way to the committee, as the county assembly need to draw a distinction between the work of the county public service board and the work of the governor within the counties. So in total, Mr. Speaker, I move, Mr. Speaker, that the House confirms our report, Mr. Speaker, that allegation count 1, allegation number 15 has been proved. But before I finish, Mr. Speaker, there is another issue that arose on public participation, Mr. Speaker. Mr. Speaker, the committee made an observation that on recall for elected members of parliament, senators, MPs, MCAs, the citizens cannot successfully prosecute a recall clause unless they collect signatures from the citizens of either the county, ward, the constituency, Mr. Speaker, or the county. So, Mr. Speaker, we made an observation that going forward, this House should consider that the task of impeaching governors should not be left solely at the discretion of members of county assembly, that there should be a law that obligates those who are proceeding with impeachment motions against governors. They should also collect signatures from members of that particular county who elected the governor. So with those remarks, I want to ask my good friend, Senator for Marsabit, Senator Adugura, to second. I thank you, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to second this special committee report on the impeachment of Governor for Wajir. Mr. Speaker, the County Assembly brought many allegations under 2 charges, and I'd like to advise the County Assembly that they are the first line of oversight, and in case there are issues, they have to first perform their duties before they bring these allegations to the Senate, because the law is very clear. If it's a county executive committee member or a county accounting officer who's a chief officer who has not performed his or her duties, then they have the powers to summon or to invite, and once they find that person culpable, then they have also the powers to recommend to the governor. They can impeach that person and have him out of office and recommend the same to the governor. In the event that maybe the governor has refused to take the ruling of the House or implement the ruling of the House, then that could be an issue which can be taken against the governor. Like in the first case of impeachment of Governor Wambora, which was, among the other charges, was that he refused to sack the county secretary who was impeached by the county assembly. So in that case, they have done their part. It was the governor who was not ready to do his part. That's why it was part of the impeachment grounds. But in this case, the county assembly brought issues which could easily be attributed in law to have been the failures of the county executive members or accounting officers, which cannot be connected to the governor. That is why in some cases where we could find, yes, as a matter of fact, the law has been broken somewhere, but it's not the governor, so we cannot impeach the governor on that. That's why we said not substantiated against the governor, but it may have happened. Then the other issue is the auditor's report, because some of these allegations are also based on the auditor's report. The county assembly also has that responsibility to take up the auditor's reports and summon the relevant county executive committee members to address issues raised in the auditor's report, so that if somebody has broken the law, then that person will be held accountable. But transferring that one as an allegation to the Senate also becomes difficult to pin the governor or to connect to the governor, because it is very clear in law that it's a particular officer. I'll cite the case like under allegation 14, which there are many procurement issues. Yes, we looked at them and found that here, in particular instances, the law has been broken. For example, the issue of ugali, where a known item, a common user item, has been overpriced. Instead of, they said 1,600 shillings per bed, it was procured at 3,500, which is a very clear case of a violation of the law. If you look at the Public Procurement and Asset Disposal Act, at section 106(4), it says that where the lowest price is above the prevailing market rate, the request for quotation shall be cancelled or terminated in accordance with cancellation and termination procedures in this act. So if you know the price of an item and the quotation, the prices is very high like this one, then the next action for the procuring officer was to cancel that, but it was not cancelled. So what does the law say? If you go to the same Public Procurement and Asset Disposal Act, section 54, part 4 says, in case of that, that the public officers involved in transaction in which goods, services, works procured unreasonably inflated prices, in addition to any other sanction prescribed in the Act, the regulation, then will be required to pay the procuring entity the loss resulting from that. So the law is very clear. If a breach has occurred, then it's the public officer involved in that procurement. So I'd like to urge the County Assembly of Wajir to take it up and check, yes, the law has been broken, but by an individual who is within their purview in terms of oversight, whom they can take action against. But taking that and transferring it to the governor will not, we will not get that connection, so we cannot substantiate as a charge against the governor. So I'd like to urge the county assemblies to look at the auditor's report, digest it, summon the relevant officers, and make them explain whatever is there, so that in the event they have taken action and the governor is not implementing, then that could be an issue which can be taken against the governor, because it's him now not acting after the breakage of law has been established against one of his officers. Mr. Speaker, so in those cases, the committee advised that the county assembly takes it up with the relevant public officers under them, so that they can remedy those breakage of law at that level instead of holding it against the governor. Mr. Speaker, some observations which I'd like to make, which some of them has been made by the mover, is that the issue of the time in terms of carrying out this impeachment process is not enough, even for the committee, which takes 10 days, which is even worse in case of preliminary, which will just take maybe the whole preliminary can sit in 2 days and justice will not be done. So I think it's for us to look at our standing orders and amend them so that we have enough time. The other one is the issue of Standing Order 75-4A, in which it says that if the special committee has found no allegation against the governor to have been substantiated, no further action is taken. My understanding is that, Mr. Speaker, the special committee, just like any other committee of the House, is working for the House. So whatever they will have established should be brought to the House, and the final say should be with the House. So in this instance, even if the committee found there will be no allegations substantiated, the report should be submitted to the House and debated, and maybe at a higher threshold, let's say maybe at a 2/3 majority, the House can overturn the findings of the committee. That way, the House will be comfortable working through the committee because the committee will not terminate the proceedings using this Standing Order 75-4A. Mr. Speaker, there are issues which, like in the charge of abuse of office, very emotive issues have been raised, but unfortunately, or fortunately as a Senate, we'll have to ask for facts before we can make any conclusion. That is why we insisted that any information provided should be admissible to us, like in the case of the bank statements, which we tried to inquire how it was acquired and all that, and the witness was not ready to give us any information, so we could not rely on it. Otherwise, when the county assembly decides to prosecute its case, it must give us enough information for us to make the decision we like or they want us to make. It's for them to push and argue their case. It's not for us to argue their case for them. Mr. Speaker, in the case of coming to the last allegation 15, which has been substantiated by the committee, health is a devolved function, and it's one of the major cornerstones of devolution. So when the health system in a county is going down, and that county gives more than 20% of its budget to health, and you're hearing strikes by county employees, then you are told main equipments in the main hospital are not working, and especially in this COVID period, you are told a budget of 194 million was given to the governor to take care of this COVID period, and among the things you expect is the oxygen plant to be working, you expect all the other equipment to be working, then you are told somebody, a health employee, passed on because there was no oxygen, the oxygen plant is not working. Then you ask, what is the problem? There is power problem. What particularly? A gadget of 5.8 million was required to connect power to have the 1,000 kVA generator to be connected to power all the equipment in the hospital, and you are told that was what's missing. Then you ask yourself, what happened to 194 million so that it could not procure a 5.8 million gadget, which is a matter of life and death for the people of Wajir. So based on that, we found that is a very serious issue, and there is no way we would have said that that is not gross. Otherwise, what will you be doing as a governor if your people are dying and you could not fix that kind of an equipment? So, Mr. Speaker, based on that, we said that that is a gross violation, and that's what we would like the House to find out and agree with the committee. And on the issue of, there was this issue of payment of contractors. This is under allegation 14, charge 1, where a county will send a requisition to the controller of budget to authorize withdrawal of funds, and that requisition has a list of the contractors to be paid. Then, when money is requisitioned and obtained based on that request, the government officer, the county government officer here, said very clearly that they don't have to pay the same people. So what was the reasoning of using that list, requisitioning for payment using that list, if it will not pay the same people? That is an issue. I'd like this House to take it up with the controller of budget and tell us whether that is the position in law. Because what the chair said is morally it's wrong, but we don't see any law which prohibits that. But personally, I feel even the law has to be in line with that morality, because in this country, we had a very long history of misuse, misapplication of public funds, and that is why all these laws are in place, and that's why even the Office of the Controller of Budget has been created to streamline all these processes. Now, if we follow the law halfway, once you get the money, you misapply it again, then that law needs to be checked. And we stopped at actually saying that somebody to be held accountable because of that doubt in law, which we need to confirm from the Controller of Budget so that we get the very clear position so that this abuse of that particular requirement does not continue, because it's happening in many counties. Mr. Speaker, with those few comments, I'd like to second this special committee report and urge the House to adopt it. Thank you.
Honorable Senators, I now propose the question, which is that whereas pursuant to Article 181 of the Constitution and Section 33 of the County Government Act 2012, on Tuesday, 27th April 2021, the Wajir County Assembly approved a motion for the removal from office by impeachment of the Honorable Mohammed Abdi Mohamud, Governor of Wajir County. And further, whereas by letter reference number SPK/WCS/Senate/4/2021-1, dated Wednesday, 28th April 2021, and received in the office of the Speaker of the Senate on Thursday, 29th April 2021, the Speaker of the County Assembly of Wajir informed the Speaker of the Senate of the approval of the motion by County Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Section 3B of the County Government Act 2012 and Standing Order number 75-1B, the Senate by resolution on Thursday, 6th May 2021, appointed a special committee comprising 11 of its members to investigate the matter on the proposed removal from office by impeachment of the Governor of Wajir County, and to report to the Senate within 10 days of the appointment on whether it finds the particulars of the allegations to have been substantiated. And whereas pursuant to Section 33(4) of the County Government Act 2012 and Standing Order number 75-2, the special committee has investigated the matter and tabled its report today, Monday, 17th May 2021. And whereas pursuant to Section 33(4) and 6B of the County Governments Act and Standing Order number 75-4B, the special committee has found that the particulars of Charge 2, namely abuse of office and gross misconduct against the Governor of Wajir County, has not been substantiated. And whereas pursuant to Section 33(4) and 6B of the County Governments Act and Standing Order number 75-4B, the special committee has found that one of the particulars of Charge 1, namely gross violation of the Constitution of Kenya 2010, the County Governments Act 2012, the Public Procurement and Assets Disposal Act 2015, and the Public Finance Management Act 2012 against the Governor of Wajir County has been substantiated. Now, therefore, pursuant to Section 33, 6B of the County Government Act and Standing Order number 75-4B, the Senate, after according the Honorable Mohammed Abdi Mohamud, the Governor of Wajir, an opportunity to be heard, resolves to impeach the Governor of Wajir County on the ground of gross violation of the Constitution of Kenya 2010, the County Government Act 2012, the Public Procurement and Asset Disposal Act 2015, and the Public Finance Management Act 2012. Senator Kajwang Moses.
Mr. Speaker, I'm rising on a point of order. Our duty today was to receive the report of the special committee, which is before us, which is a remarkable report that was signed over well. It was signed by all the members of the committee. Our other duty today was to listen to the governor in his defense. The other duty was to consider all the facts before us and finally to take a vote. I just needed your guidance whether this is a time where we are calling the governor so that we don't have to debate before we have listened to the governor. Thank you, Mr. Speaker.
Our procedures and the way we've done it in the past is that the governor has the last word after you have made your contributions, those who want to contribute. What's your point of order? Who is that, Senator? You're not on.
Mr. Speaker, then I move that we proceed to hear the governor, unless any member has a burning issue to debate. Thank you.
I can see Senator. Senator James Orengo.
Mr. Speaker, I think there is some good reason in what Senator Kajwang is saying, because it must never be lost to us that now we are like the court itself. We are going to reach a verdict. And before we say everything good or bad, maybe we may be persuaded either way. And I think it would be important to give the governor a chance. And then we will now be contributing to the motion on the basis of what we have heard from him, as against us talking, and then eventually the governor speaks, and we cannot come back and again comment on what he has said. So I know that the procedure may be there from the past, but I don't think it's well articulated in the standing orders that the governor is the last person to speak. But even if he was the last person to speak, I think the rules of natural justice would apply, because we are not accusers. We are not accusers. We are not accusing the governor. We are hearing the case of the governor and then making the decision. We have heard the committee and its finding, and maybe the governor may have a comment on that report, and then we can debate the motion on the basis of what we have heard from the governor.
Senator Chilayako.
Thank you, Mr. Speaker. Mr. Speaker, this is a matter that this House rightly asks you to apply your discretion and depart from the precedents. It's not proper for us to give our opinion, to give our positions before hearing any additional facts that the governor may have. Again, it flies on the face of Fair Administrative Actions Act when we comment before hearing the full story. So, Mr. Speaker, just like Senator Kajwang and Senator Orengo, I implore you, plead with you to depart from the tradition or convention and have us hear the governor, so that we can contribute from the position of knowledge and from the position of facts. Thank you, Mr. Speaker.
Senator Wamatangi.
Mr. Speaker, I rise also to support the position as expressed by my colleagues, and indeed as proposed by Senator Mwenyehaji Faki, Mr. Speaker, because for all intent and purposes, Mr. Speaker, whatever the governor will be saying at the point when he is invited, be it the equivalent in court proceedings of either mitigation or defense, Mr. Speaker, it is supposed to help his case. And because, Mr. Speaker, the people who will be making the decision, finally, after hearing what the governor has to say on the charge, Mr. Speaker, that has been substantiated. Mr. Speaker, I want to support the position that the most prudent thing to do, so that, Mr. Speaker, the process can be as flawless and as justice-filled as it should be, Mr. Speaker, is to allow the governor to come to the House and, Mr. Speaker, make his remarks or his comments, Mr. Speaker, indeed, or mitigate or defend himself, that we should be full and knowledgeable of all the things that, Mr. Speaker, the governor would want to say, and then we can proceed to make a decision. So, Mr. Speaker, I support the position that we invite the governor to make his comments.
Senator Haniri.
Mr. Speaker, Senator Faki moved that
we hear the governor. He was not seconded. I want to be on record that I'm seconding him. Mr. Speaker, the standing orders are not very clear on this particular procedure. It just says that having substantiated, the Senate shall, after according the governor an opportunity to be heard, vote on the charges. So the matters have been substantiated some, and I think it is only fair that before we take a vote, and of course a vote will be preceded by debate if there are those who wish to make some contributions and observations, it is only fair that we listen to both sides. My colleagues have put it very well, the lawyers who have spoken before me, that in this particular matter we elect the judges, so we cannot give our verdict having only listened to one side of the story. So I think it is just fair that at this stage we bring in the governor to make his address. Then you can now open to members for debate and voting. Thank you.
Senator Cherargei.
Thank you, Mr. Speaker. Maybe to add on that, and before we decide, because we have a committee report already that has been tabled, number one. So I don't know when the governor speaks, because I have also read the standing orders, when the governor speaks, should we, in part of the report, when we are reacting, is to the point. Mr. Speaker, protect me. I don't know why Murkomen is.
Yeah.
Yes.
Senator Murkomen, you are entering with a lot of drama.
So, Mr. Speaker, I've read the orders, and it is not clear, as Senator Kaniri has said. But my opinion is that there is a report that is already here. We want the governor to speak, but I think to be neat, it is better to react and respond to what the governor is saying inter alia with the report that has been tabled by the committee, so that we can be neat, then we react and vote. I support Mr. Speaker, sir.
Senator Cheriot. Thank you for this chance. The right to a fair trial is a cardinal principle in this constitution of ours, Mr. Speaker. What will be a fair trial for the governor in light of what has happened, bearing in mind our constitution, the standing orders, and all matters before us? At 2:30 when we walked in this afternoon, Mr. Speaker, those of us who are not members of this committee received the report. The report almost has 300 pages. I know Senator Wetangula has before tried to convince the House that lawyers have a formula for reading faster than the rest. There is no scientific evidence to confirm that. And we can put even the lawyers in this House through a test of the 300-page plus document. And they will do just as the rest of all of us, Mr. Speaker. So what will be a fair trial to the governor for Wajir? I think I want to agree with the proposal by Senator Mohamed Faki, as seconded by Senator George Aniri, that in addition to reading through the report, Mr. Speaker, giving the governor a chance to make his case before us, especially at this point where he knows the verdict that the committee have arrived at and the conclusions that they made, will be a good place to start the debate leading to our decision making as a Senate. Because, Mr. Speaker, what will happen is that he will explain himself, and as such, as seated as a jury, we will listen to his rebuttal to what the report accuses him of. Then afterwards, each of us will be free to air their findings in whatever, whether they agree with the committee report or with the defense or that the governor will have put up here by himself. Therefore, Mr. Speaker, I support this proposal that let us listen to the governor at this particular point. Then later on, we can have a debate having listened to both parties. Thank you, Mr. Speaker.
Senator Murkomen.
Thank you, Mr. Speaker. The proposal to bring the governor before our debate, Mr. Speaker, I think again is one of those very important innovations that we are putting forward after learning from the past experience. Because the Speaker, the governor already knows his verdict, the verdict of the committee. Coming before us is like an appeal. So it's better he makes his case first, Mr. Speaker, before now we can sit and converse and make a determination. Because if I will have made my position known during the debate before the governor speaks, the Speaker, it becomes even contradiction for me now to vote after that, having been convinced by the governor, and yet I'm on record having taken a particular position. So whereas this is the first time we're going to do this, I think, Mr. Speaker, it's a better way to do it. Governor speaks first, then we have an opportunity now to consider what would be, in my opinion, part of his appeal, and then apply the same to our debate and the vote. So I think that will be, this has been unique in this governor's trial from the time we started with the committee, the process with which we identify the committee members. And I don't think, with your permission, Mr. Speaker, this would be a better way of doing it. Thank you, Mr. Speaker.
Senator Wetangula.
Thank you, Mr. Speaker. Mr. Speaker, what we are faced with now bears us out that law is indeed dynamic. Dynamic to the extent that every other day you encounter something new. Previously, Mr. Speaker, we normally, like in the Wambora impeachment, the report is tabled, moved, seconded, debated, then we hear the governor, then we retreat into something called camera, discuss again, then open up and vote publicly. But I'm persuaded by Senator Faki and those who have spoken. Our Constitution says justice shall be dispensed without any due regard to unnecessary technicalities. And given what we have, Mr. Speaker, I know that some lawyers here may hold a different view, but having listened to the mover and the seconder, who listened to first-hand evidence and who have brought a report, apart from our personal opinions on the report, none of the members here is going to advance an evidential argument other than what we have. To that extent, Mr. Speaker, then, vague as it looks, the proposal by the distinguished senator for Mombasa, supported by other senators, falls squarely within the ambit of Standing Order 75-4B. If the special committee reports that the particulars of an allegation against the governor have been substantiated, the Senate shall, after according the governor an opportunity to be heard, vote on the charges. This particular standing order doesn't even seem to anticipate debate, although we have been debating and we will make our comments along the way. So it might be good, Mr. Speaker, in my view, to hear the governor, and those who have proposed as such, I think, have a point. A departure as it may be from our previous proceedings, but it's not in violation of any standing order. It is in fact in sync with the Standing Order 75-4B. So I concur that we can call the governor and Article 50 of the Constitution, yes, that talks of fair trial. So, Mr. Speaker, I urge you to, in making your ruling, to consider the things we have said, and if the governor is around, we hear him.
Okay, order, senators. Senator Cherargei.
Okay, Honorable, you are all over the House. Honorable Senators, I've heard you, and I want to use discretion of Standing Order number 1 and put a question, a voice question, following what Senator Faki has proposed and seconded by Senator Haneri. Ask that as many are of that opinion that the governor comes now before debate, say aye. Aye. As many are of a contrary view, say nay. The ayes have it. So we will have the governor, let him come. The governor or his lawyer will give you, to start with, I will give him 30 minutes. Governor, are we ready? Okay, the governor will be heard through his lawyer. So you are welcome. I've said, giving you an initial. I'm sure. Yes.
Members, my name is Ndegwa Njiru. With me, with my colleague, my line friend, Mr. Mburu. We are here on behalf of the governor. However, spoke to him when this session began. Mr. Speaker, sir, he was slightly taken ill, but he has been able to recover and is on his way. He has advised me to come and seek your indulgence, to at least indulge him for about 10 to 15 minutes, so that he can be able to avail himself. For one reason, Mr. Speaker, sir, that the governor is on trial and deserves to be heard. If it so pleases you, Mr. Speaker, we so seek indulgence, then you shall allocate time to us, because we intend to give him about 5 minutes, then we shall do the sum up of our summations. Much obliged.
That's okay. It's granted. 15 minutes. What's your point of order? Senator Murkomen, so that I make a decision.
Thank you, Mr. Speaker. Considering the request that came from the governor's lawyer, Mr. Speaker, in this very difficult time, it is not, Mr. Speaker, surprising to find anybody falling ill, Mr. Speaker. It's possible in this very difficult trial. But now I'm asking, are we not, we should find the right standing order with which we adjourn for a certain period of time. And Mr. Speaker, is it not in order for either minority leader or majority leader to move a motion for adjournment, Mr. Speaker? Is it purely a discretion of the Speaker?
Yes.
Because I thought the leader should
no, Senator Murkomen, what I will do is use Standing Order number 1 and just suspend the House for 15 minutes so that we come back at a quarter to 5. Okay. Oh, quarter to 6.
The Speaker of the Senate, Honorable Ken Lusaka, has yet again directed that the House takes a short break, that is a break of 15 minutes. This is to allow for the governor for Wajir County to make his way into the Senate chambers and make his speech before senators take a vote on the report by the 11-member committee. Through his lawyer Ndego Wanjiru, the governor says he deserves the right to be heard before senators take the crucial vote on that particular report, and that's why the House is adjourning briefly to allow for the Honorable Governor to make his way. You'll also remember that the committee, comprising of 11 senators, have recommended for his removal from office based on one particular charge of gross misconduct and violation of the 2010 Constitution. Honorable members of Wajir County Assembly impeached the governor based on 2 particular cases. Among them is gross violation of the 2010 Constitution. Honorable members of Wajir County Assembly impeached the governor based on 2 particular cases. Among them is gross violation of the Constitution as well as abuse of office. And according to the report by the committee led by Senator Omogeni, the first charge on the gross violation of the Constitution of Kenya and the County Government Act of 2012 has been substantiated. And so senators will also be diverging more on that particular report, also hear from the governor before they take that crucial vote that will either save the governor or seal his fate. According to the standing orders on matters voting on this particular case, the report by the Senate committee will require 24 senators to vote in support of it, and that will be sealing his impeachment case as impeached by members of the county assembly. And in the event that threshold is not met, then the governor for Wajir County will have survived the impeachment motion. We are taking a short break. We'll resume after a short period of time. Keep watching. My name is Gladys Mungai.